The House Judiciary Committee hearing room was packed to capacity on that Tuesday morning. Jim Jordan, the powerful Republican congressman from Ohio, adjusted his yellow tie and leaned into his microphone, a familiar smirk spreading across his face. Across from him sat Representative Jasmine Crockett, the freshman Democrat from Texas, reviewing her notes one final time. Jordan's voice boomed through the chamber as he looked directly at Crockett. Perhaps the gentlewoman from Texas should go back to law school before lecturing this committee on constitutional matters, he said, his tone dripping with condescension. The room stirred with murmurs. Several Republican members chuckled. But what happened next would become one of the most devastating takedowns in congressional history. Crockett slowly lifted her eyes from her papers, locked them onto Jordan's, and delivered a response so precise, so methodical, and so brutally effective that it would leave the veteran congressman speechless and his political reputation in tatters. Before we dive into this explosive confrontation that garnered over 30 million views in just 24 hours, make sure to hit that like button and subscribe to our channel. Ring the notification bell so you never miss these crucial moments that shape American politics. Drop a comment below letting us know where you're watching from. Now, let's witness how a first-term Congresswoman absolutely demolished one of the most powerful Republicans in Washington. The tension had been building for weeks. Jim Jordan, aged 60, had positioned himself as the Republican Party's attack dog in the House Judiciary Committee. Known for his aggressive questioning style and his unwavering loyalty to conservative causes, Jordan had spent over 16 years in Congress building a reputation as someone who could destroy any witness with his rapid-fire interrogations. His background as a former wrestling coach at Ohio State University had given him a combative edge that he wielded like a weapon in committee hearings. He never wore a suit jacket, preferring to roll up his sleeves as if preparing for a physical fight. His fundraising emails regularly touted his ability to own the libs in congressional hearings, and his YouTube clips generated millions of views from conservative audiences who loved watching him tear into Democrats. Standing in stark contrast was Jasmine Crockett, 42 years old, representing Texas's 30th congressional district. She had only been in Congress for 14 months, but her background was formidable. Before entering politics, Crockett had spent over a decade as a public defender and civil rights attorney in Dallas. She had graduated from Rhodes College and earned her law degree from the University of Houston Law Center. Unlike Jordan, who held a law degree from Capital University Law School, but had never actually practiced law, Crockett had spent years in actual courtrooms, defending clients whose lives hung in the balance. She knew the law not as an abstract concept, but as a living, breathing tool that could mean the difference between freedom and incarceration. The hearing that morning was supposed to focus on oversight of the Department of Justice's handling of various investigations. Jordan had called the hearing specifically to challenge what he called the weaponization of federal law enforcement against conservatives. He had prepared for weeks, his staff compiling binders of what they believed was damaging evidence. Fox News had already scheduled him for primetime appearances that evening to discuss his expected victory. The conservative media ecosystem was primed and ready to amplify whatever viral moments Jordan could create. But Jordan had made a critical miscalculation. He had assumed that Crockett, being relatively new to Congress and significantly younger than him, would be an easy target. He had watched her previous committee appearances and noticed she often spoke softly, methodically presenting her arguments without the theatrical flair that dominated modern congressional hearings. To Jordan, this suggested weakness. He couldn't have been more wrong. The morning started predictably. Jordan delivered his opening statement with characteristic bombast, accusing the Justice Department of unprecedented constitutional violations and claiming that basic legal principles were being thrown out the window for political purposes. He cited several cases, throwing around legal terminology with the confidence of someone who had never been challenged on his understanding of the law. He mentioned the Brady Doctrine, the exclusionary rule, and various constitutional amendments, weaving them into a narrative of governmental overreach that his base would find compelling. When it came time for member statements, Crockett initially seemed to follow the standard format. She thanked the chairman, acknowledged the witnesses, and began discussing the importance of judicial oversight. Her voice was calm, measured, professional. Jordan barely paid attention, scrolling through his phone as she spoke. That's when she mentioned something that made him look up. "Mr. Chairman," Crockett said. You've made several references to legal principles today that I find interesting, particularly given your interpretation of Brady versus Maryland. Jordan's head snapped up. The Brady case was something he had cited dozens of times in hearings and media appearances. It was one of his go-to examples when discussing prosecutorial misconduct. He considered himself somewhat of an expert on it. I'm happy to educate the gentlewoman on constitutional law, Jordan interjected, that familiar smirk returning to his face. Though I understand not everyone here has spent as much time studying these matters as some of us have. The room grew quiet. Several Democratic members exchanged glances. Republican members seemed to settle in for what they expected would be another Jordan demolition. But Crockett's expression didn't change. She simply nodded and continued. That's very generous of you, Mr. Chairman, she replied, her tone remaining perfectly professional. Since you're offering to educate me, perhaps you could explain which specific holding from Brady you believe applies to the situation you described earlier. Jordan leaned back in his chair, his confidence evident. Well, obviously, Brady requires prosecutors to turn over exculpatory evidence to the defense. It's basic law school stuff, Congresswoman. Perhaps if you'd paid attention in criminal procedure class, you'd know that. The insult hung in the air. Several Republicans chuckled. Matt Gaetz actually laughed out loud. But Crockett remained composed, making a small note on the paper in front of her. I see, she said slowly. And when you say exculpatory evidence, are you referring to material exculpatory evidence or impeachment evidence? Because Brady actually distinguishes between the two, and the standards for disclosure are different. Jordan's smirk faltered slightly. Both, obviously. The prosecution has to turn over both. Actually, Mr. Chairman, Crockett responded, pulling out a document. That's not quite accurate. The timing requirements differ significantly between material exculpatory evidence and impeachment evidence. United States versus Ruiz, 536 U.S. 622, specifically held that impeachment evidence does not have to be disclosed during plea negotiations. Did you mean to conflate these two distinct categories, or were you simply unaware of the distinction? The room stirred. Jordan's face began to redden. I've been talking about Brady for years, Congresswoman. I think I know what it means. I'm sure you've been talking about it for years, Crockett replied, her voice still calm, but now carrying an edge. But talking about something and understanding it are two very different things. For instance, you just claimed that your interpretation was basic law school stuff. Well, Mr. Chairman, I did go to law school. I graduated from the University of Houston Law Center. I passed the bar exam. I practiced law for over a decade. And in all that time, I never once heard Brady described the way you just described it. She paused, letting her words sink in. But perhaps Capital University Law School teaches it differently. Oh wait, she continued, her tone sharpening. You never actually took the bar exam, did you, Mr. Chairman? You got your law degree in 2001, but chose not to become a licensed attorney. So when you mock my law degree and suggest I need to go back to law school, I have to wonder, what exactly qualifies you to evaluate anyone's legal education when you never even attempted to practice law yourself? The room went completely silent. Jordan's mouth opened and closed, but no words came out. The power dynamic had shifted dramatically. The hunter had become the hunted. But Crockett was just getting started. She pulled out another document. Since we're on the subject of legal education, Mr. Chairman, let's discuss some of the other legal principles you've mentioned today. You cited Marbury versus Madison earlier as supporting your position on judicial review of executive actions. Could you tell the committee what Chief Justice Marshall actually held in that case? Jordan, now visibly flustered, attempted to recover. Everyone knows Marbury established judicial review. That's a very surface-level understanding, Mr. Chairman, Crockett responded. Marbury actually held that while the Supreme Court has the power to review acts of Congress and the executive, it cannot issue writs of mandamus to executive officials in their discretionary functions. The case you're thinking of, the one that would actually support your argument, would be Youngstown Sheet and Tube Company versus Sawyer. But you didn't cite that, did you? Because you don't actually know the cases. You just know the talking points. Democratic members were now struggling to hide their amazement. Alexandria Ocasio-Cortez was taking notes furiously. Jerry Nadler, the ranking member, was watching with barely concealed delight. Even some Republicans looked uncomfortable with how badly this was going for their colleague. Jordan tried to interrupt. This is ridiculous grandstanding. No, Mr. Chairman, Crockett cut him off. What's ridiculous is you sitting in that chair, leading the Judiciary Committee, making legal arguments you don't understand, citing cases you haven't read, and then having the audacity to mock my legal education. I've tried cases. I've written briefs. I've stood before judges and made arguments where people's freedom depended on my understanding of the law. What have you done besides give speeches and send fundraising emails? She pulled out a thick folder. I've brought something interesting for the committee to review. These are transcripts from your previous hearings where you've discussed legal issues. I've had them reviewed by constitutional law professors from Harvard, Yale, and Stanford. Would you like to know what they found? Jordan's face was now deep red. This is a waste of the committee's time. On March 15th, Crockett continued, ignoring his protest. You claim that the Fourth Amendment prohibits all warrantless searches. That's simply false. There are numerous exceptions: search incident to arrest, automobile exception, plain view doctrine, exigent circumstances, consent. These are first-year law school concepts, Mr. Chairman. She flipped to another page. On April 22nd, you said the Sixth Amendment guarantees a jury trial in all federal cases. Wrong again. Petty offenses with maximum sentences of 6 months or less don't require jury trials. Lewis versus United States, 518 U.S. 322. Did you not know this? Or were you deliberately misleading the public? The room was electric with tension. Jordan's usual allies were silent. No one was coming to his rescue. On May 10th, Crockett continued relentlessly. You claimed that Miranda warnings are constitutionally required in all custodial interrogations. But Chavez versus Martinez, 538 U.S. 760, held that failure to give Miranda warnings does not itself violate the Constitution. It only bars the use of statements at trial. That's a crucial distinction that any practicing lawyer would know. She set down the folder with a deliberate thud. Mr. Chairman, I have 47 more examples of you making fundamental legal errors in official committee proceedings. And these aren't matters of interpretation or political disagreement. These are basic, black-letter law principles that any first-year law student would know. But you don't know them because you never practiced law. You never took the bar exam. You never had to actually understand these principles well enough to use them in real cases with real consequences. Jordan tried one more time to salvage the situation. My record speaks for itself. I've been a champion of conservative values and constitutional principles. Your record does speak for itself, Crockett interrupted. It shows that you've spent 16 years cosplaying as a legal expert while not understanding basic legal concepts. It shows that you use this committee as a platform for political theater rather than serious oversight. And it shows that when confronted with someone who actually knows the law, your only response is to mock their education because you have no substantive response. She turned to address the rest of the committee. Members of this committee, we have a serious responsibility to conduct oversight of our justice system. That requires actually understanding how the law works. It requires more than talking points and sound bites. It requires the kind of knowledge that comes from real legal education and practice. Turning back to Jordan, she delivered her final blow. So, Mr. Chairman, when you suggested I should go back to law school, you revealed more about yourself than you did about me. I did go to law school. I did graduate. I did pass the bar. I did practice law. The question is, why didn't you? Was it because you knew you couldn't pass the bar exam? Or was it because you realized that actual legal practice requires precision and accuracy that political grandstanding doesn't? The silence that followed was deafening. Jordan sat frozen, his usual combative energy completely drained. His chief of staff was whispering urgently in his ear, but Jordan wasn't listening. He had been exposed, thoroughly and completely, in front of the entire country. Representative Matt Gaetz tried to come to Jordan's defense. Point of order, Mr. Chairman. The gentlewoman's time has expired, and these personal attacks. Personal attacks? Crockett turned to Gaetz. I'm citing the public record. Every statement I've made is documented. Every case I've referenced is real. Every error Mr. Jordan made is on video. If accurately describing someone's record constitutes a personal attack, then perhaps the problem is with the record, not the description. The committee's Democrats couldn't hide their satisfaction any longer. Representative Eric Swalwell was openly grinning. Representative Pramila Jayapal was nodding approvingly. Even some Republicans looked impressed despite themselves. Jordan finally found his voice, though it lacked its usual force. "The gentlewoman's time has expired. We need to move on to witness testimony." "Of course, Mr. Chairman," Crockett replied smoothly. "Though I do hope that in the future, when you discuss legal matters, you'll ensure your statements are accurate. The American people deserve committee leadership that understands the law it claims to be protecting." As she settled back in her seat, the hearing room erupted in whispers. Reporters were already typing furiously on their phones. The clip was being uploaded to social media before the hearing had even moved to the next speaker. Within minutes, "Crockett destroys Jordan" was trending on Twitter. The video spread across platforms like wildfire. Liberal commentators were calling it the most brutal takedown they'd ever witnessed in Congress. Even some conservative voices admitted that Jordan had been outmatched. The immediate aftermath was chaos. Jordan called for a 5-minute recess, ostensibly for a bathroom break, but everyone knew he needed to regroup. Republican members huddled together, trying to figure out how to respond. Democratic members were trying to contain their excitement. But the damage was done. The video was already going viral. Political commentators were breaking down the exchange moment by moment. Legal experts were confirming that Crockett's corrections were accurate. Law professors were praising her precise dismantling of Jordan's pseudo-legal arguments. By the time the hearing resumed, Jordan was a shadow of his former self. He spoke less, interrupted less, and avoided making any legal claims that Crockett might challenge. The dynamic of the entire hearing had shifted. Other members began directing their substantive legal questions to Crockett rather than Jordan, implicitly acknowledging her superior understanding of the law. The witnesses, who had prepared for Jordan's typical aggressive questioning, found themselves facing a subdued chairman who seemed afraid to venture into legal territory. His questions were shorter, less pointed, and notably devoid of the constitutional grandstanding that usually characterized his performances. During the lunch break, Jordan's staff scrambled to do damage control. They released a statement claiming that Crockett had mischaracterized the chairman's statements, but they couldn't point to any specific inaccuracies in what she had said. Every case she cited was real. Every correction she made was valid. Every document she referenced was authentic. The conservative media response was telling. Fox News, which had planned extensive coverage of Jordan's hearing, suddenly scaled back their coverage. The scheduled primetime appearances were quietly canceled. Conservative commentators who usually rushed to Jordan's defense were notably silent or offered only lukewarm support. Meanwhile, Crockett's office was flooded with calls and messages of support. Law schools reached out wanting her to speak to their students. Legal organizations praised her for standing up for accuracy in legal discourse. Young lawyers, especially women and people of color, saw her as an inspiration, someone who proved that knowledge and preparation could triumph over bluster and seniority. The long-term impact was even more significant than the immediate embarrassment. Jordan's reputation as a fierce interrogator was permanently damaged. Future witnesses came to hearings knowing that Jordan's legal arguments could be challenged. Committee members who had previously deferred to his supposed legal expertise began questioning his assertions. 3 days after the hearing, a group of law professors published an open letter in the New York Times. They confirmed that every legal correction Crockett had made was accurate and praised her for demonstrating the importance of actual legal knowledge in congressional oversight. They also noted that Jordan's errors weren't minor technicalities, but fundamental misunderstandings of basic legal principles. The Ohio Bar Association released a carefully worded statement noting that while Mr. Jordan was not a member of the bar and thus not subject to their oversight, they encouraged all public officials discussing legal matters to ensure their statements are accurate and well-informed. It was a diplomatic but clear rebuke. Jordan tried to recover with a defensive op-ed in the Wall Street Journal, arguing that real-world experience mattered more than ivory tower legal theories. But the response was brutal. Legal commentators pointed out that Crockett had more real-world legal experience than Jordan, having actually practiced law for over a decade while Jordan had never practiced at all. A week after the hearing, polling showed that Jordan's approval rating in his own district had dropped by 12 points. More significantly, his fundraising took a serious hit. The small dollar donations that had fueled his political operations slowed to a trickle. Major donors began expressing private concerns about his effectiveness. Meanwhile, Crockett's star continued to rise. She was invited to appear on major news programs to discuss legal issues. Her fundraising exploded, with donations pouring in from across the country. Progressive organizations began mentioning her as a future leader of the party. There was even speculation about her potentially running for Senate or serving in a future Democratic administration as Attorney General. But perhaps the most significant impact was on the culture of the Judiciary Committee itself. Members began coming to hearings better prepared, knowing that false legal claims could be challenged. Staff started fact-checking legal assertions more carefully. The quality of legal discourse in the committee notably improved. Young congressional staffers began referring to pulling a Crockett, meaning thoroughly preparing to demolish an opponent's arguments with facts and evidence. Law schools started teaching the exchange as an example of how to effectively counter misinformation about legal principles. The video of the exchange was viewed over 50 million times across various platforms. It was subtitled in dozens of languages and shared internationally as an example of effective democratic discourse. Political science professors used it to teach about power dynamics in congressional committees. For Jim Jordan, the humiliation was complete and lasting. He never fully recovered his previous swagger in committee hearings. He became notably more cautious about making legal claims, often deferring to staff or other members on specific legal questions. His media appearances decreased, and when he did appear, hosts would sometimes reference the Crockett exchange, causing visible discomfort. 6 months later, when Jordan announced he would not seek re-election as Judiciary Committee chairman, political insiders universally understood that the Crockett confrontation had played a significant role in that decision. He had been exposed as a legal pretender, someone who had built a career on false expertise, and that exposure had been too devastating to overcome. Crockett, for her part, handled her newfound prominence with grace and focus. In subsequent interviews, she emphasized that the confrontation wasn't personal, but about the integrity of legal discourse in Congress. When we discuss the law in these chambers, she said in one interview, "We're not just having academic debates. We're shaping policies that affect millions of Americans. We owe it to them to get the law right." She also used her platform to advocate for better legal education among lawmakers. She proposed legislation requiring members of the Judiciary Committee to undergo annual legal education sessions, taught by practicing attorneys and judges. While the proposal faced resistance, it sparked a national conversation about the qualifications of those overseeing the justice system. The confrontation also inspired a new generation of political candidates with actual legal experience to run for office. Law schools reported increased interest from students in pursuing political careers. Bar associations began programs to encourage their members to consider public service. A year after the hearing, Harvard Law School published a case study on the exchange, analyzing it from multiple angles: the legal arguments, the rhetorical strategies, the political implications, and the role of expertise in democratic governance. It became required reading in several courses on law and politics. The phrase "Jim Jordan's law degree" became internet shorthand for false expertise or unearned authority. Memes proliferated showing Jordan's confused face with captions like, "When you realize your opponent actually went to law school," or "That moment when talking points meet actual knowledge." For the Democratic Party, Crockett became a symbol of a new generation of leaders who combined professional expertise with political skill. She was featured prominently in campaign materials and became a sought-after surrogate for candidates across the country. Her endorsement carried significant weight, particularly in races where legal issues were prominent. The Republican Party, meanwhile, began quietly recruiting more candidates with actual legal backgrounds for judiciary positions. The era of appointing committee members based solely on political loyalty or media skills was ending. Expertise was suddenly back in fashion. In her own reflection on the incident, published in a law review article a year later, Crockett wrote, "The confrontation with Chairman Jordan wasn't about embarrassing a political opponent. It was about defending the integrity of legal discourse in our democratic institutions. When we allow false legal claims to go unchallenged, we undermine the rule of law itself. Every lawyer, whether in Congress or in a courtroom, has a duty to correct legal misinformation when they encounter it." The article was widely praised and became one of the most cited law review pieces of the year. It was assigned reading and legal ethics courses across the country and influenced discussions about the role of lawyers in public life. The transformation was complete. What had started as Jim Jordan's attempt to mock a freshman congresswoman's legal education had ended with his own expertise being exposed as a facade. Jasmine Crockett had not just defended herself. She had elevated the standard for legal discourse in Congress and proved that knowledge, preparation, and actual expertise would always triumph over bluster and false authority. The hearing that day had lasted just over 3 hours, but the moment that mattered, the exchange that changed everything, had taken less than 10 minutes. In those 10 minutes, Jasmine Crockett had dismantled 16 years of Jim Jordan's carefully constructed image as a legal authority. She had shown that in the end, you can't fake expertise when facing someone who actually has it. As one political commentator noted, Jordan learned the hard way that there's a difference between playing a lawyer on TV and actually being one. Crockett didn't just win an argument. She exposed the hollow nature of performative expertise that has infected our politics. And she did it with nothing but facts, preparation, and genuine knowledge. The lesson was clear and lasting. In an era of information and easy fact-checking, false expertise could no longer hide behind volume and aggression. The truth, when wielded by someone with the knowledge and courage to speak it, would always prevail. Jim Jordan had mocked Jasmine Crockett's law degree, but in the end, it was her actual legal education and experience that silenced him and the entire room. For anyone who's made it this far, you've witnessed one of the most significant political takedowns in modern congressional history. If you found this breakdown valuable, please hit that like button and share this video with others who need to see what happens when real expertise confronts false authority. Subscribe to our channel and ring that notification bell so you don't miss our next deep dive into the moments that shape American politics. Drop a comment below. Do you think Jordan deserved this public humiliation, or did Crockett go too far? We read every comment and want to hear your perspective on this historic confrontation. Until next time, remember, preparation beats pretense, facts beat fiction, and knowledge beats noise every single time.